How often should you update your estate plan? This may seem like a simple question, but imagine what it's actually like after your trust signing. The attorney hands you a big book, and from there, if your goal was to skip probate and make things as simple as possible for your family, there's one thing that we want to make sure doesn't happen, and that is that the trust book is tossed in a drawer and forgotten about for about 15 years. The reason we care about this is number one, clients unfortunately often attribute a kind of magic to trust and contracts in general. They forget that a trust contract is just a book of inanimate paper, and people need to do things in the real world to make sure that that book will actually help their loved ones achieve the goals they originally wanted achieved. In this video, we're going to break down on one, neglected estate plans fail in achieving their goals. Two, what events to keep an eye on that should prompt you to reach out to an attorney. And I want to emphasize that these are the most important parts. Simple housekeeping items that serve to keep you on track to achieve your goals. This episode is for the following people: families that own a trust, real estate owners, business owners, people that want to do the right thing by their families and achieve their goals. By the end of this video, I expect you all to be experts at something called trust funding and to know when to make important updates to your estate plan to protect those you love the most. This issue is particularly important to me. I have over 10 years experience designing and planning people's estates, and when you put as much time as I do in a single estate plan, you really want to see it work for the client. All we're really talking about is a few simple protocols to keep in mind to make sure your goals are achieved. So let's list out our trigger points and then break them down as to what you want to be thinking at the time and when to touch base with an attorney. So our first is going to be a change in your goals. The second is going to be you purchase new real estate. The third is going to be you open a new bank account, retirement account, or purchase insurance. And the fourth is you get an inheritance or the estate otherwise suddenly grows in size. Number 5 is going to be the divorce, birth of a new child, or other major life change to family structure. So first off, changing your goals. I'm a big advocate for identifying client goals during the estate planning process. When the client can clearly identify goals, I can act as a proper counselor, assisting them in moving towards those goals. We shouldn't lose sight of that after the plan has been completed. Rather than throwing the trust contract into a drawer and forgetting about it, why not dust it off every 4 to 5 years? Review it and make sure that you're still happy with the way everything is being distributed and with who is managing the plan. Make sure that it continues to reflect your values and goals. If you feel that it doesn't, this is a good time to reach out to a lawyer for a consult. Number 2, you purchase new real estate. A lot of my mutuals don't explain how important this is, and if they do, it's at the trust signing and you can feel like you're drinking from a fire hose. So let's have a good review of this point. If you are selling real estate that you own as the trustee of your trust, that's a very turnkey and easy process. However, if you purchase new real estate, we want to be very, very vocal to the parties involved that your trust exists. Our goal is to have it where you show up to the real estate signing, and at that point, when the warranty deed is presented to you, it shows you owning the property as the trustee of the trust. So to put that simply, the misconception people have and what gets them in trouble is that they think just because they own a trust, when they purchase new real estate, it automatically ends up in the trust. I'm going to repeat that. Because you own a trust, when you purchase new real estate, it does not automatically end up in the trust. A deed had to have been prepared that put the property into the trust. If you own a trust and you purchase new real estate, since signing the trust, you should reach out to an attorney to make sure that it is in fact in the trust. You should write that down and do it. If you're thinking of having the trust drafted, make sure that you understand that this is going to be the minimal upkeep you're going to have to do. Every time you purchase real estate, you're going to have to be vocal about the existence of the trust, or else your family is probably going to have to be going through the probate system. Number 3, you open new accounts or purchase new insurance. This next one is less of a big deal, but I want to plant a mental flag here. No, if you own a trust, every time you open up a new bank account, retirement account, or purchase a new insurance policy, you do not need to contact the attorney. However, you do want to make sure that the beneficiary is properly designated on it, whether it's going to be an individual person or the trust. As an example, if I had a client whose goal was to avoid the probate system and we set up everything correctly, and then years later that client goes and opens up a new bank account, moves $150,000 into it, and forgets to set beneficiary forms on the account, guess what? That one account is going to go through the probate system. Just be mindful of the trust's existence, your overarching goals, and the way everything fits together to achieve those goals. And if beneficiary form sounds like something new for you, it might be worthwhile to call an attorney and make sure that those designations are in fact aligned with your legal documents. Number 4, you get an insurance or inheritance or the estate otherwise suddenly grows in size. There are a few net worth thresholds where we become concerned for tax purposes. These are when an estate grows past $4 million, when an estate grows past $8 million, and when an estate grows past $14 million. Note these totals also include insurance. Even a modest American estate can suddenly blow over $4 million once you factor in cheap term insurance. It's not uncommon for us to have families with small children who own $2 to $3 million in term insurance. Once an estate grows past any of those thresholds, you really need a professional to look at it and to make sure that we aren't going to have death tax problems. Number 5, divorce, birth of a new child, or other major life changes to family structure. It goes without saying that it's best to not accidentally leave your divorced spouse as your primary agent on your power of attorney, imbued with the ability to make life or death healthcare decisions for you. Basically, any kind of major life change, new child born, divorce, etc., it's not a bad idea to check in with an attorney and make sure everything is still up to date. If it's been a while, as a general rule of thumb, I find most clients benefit from a review every 3 to 5 years just to see if anything has changed and refresh everyone's memory about the plan and how it works. If it's been a while, or if you're not sure about any of the above, it might be a good time to schedule a quick review meeting. If you found this helpful, you'll definitely want to check out our next video, Common Estate Planning Mistakes and How to Avoid Them. We break that topic down again into plain English so you can best understand how to protect your family and loved ones. Schedule a consultation today. Call us at 847-802-9912. Thanks for joining us.